Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
I'm Marnie Baizley. I'm one of the lawyers at SpringLaw, and I'm here today with one of my colleagues, Lexa Cutler, for our monthly Spring Forward webinar. Lexa is also an employment contracts labor lawyer. If you're one of our clients, you already know that we're an employment, labor, and contracts firm. If you're new to our webinars, welcome. We're a fully virtual firm based in Ontario, and SpringLaw does this webinar every third Wednesday of the month, and we cover different legal topics in each webinar, and our topics are very much driven by the issues that we're hearing about from our clients, both employer clients and employee clients. A couple of housekeeping issues before we get started. Throughout the time today, feel free to ask any questions using the chat function, and our team will send us the questions and we'll try to address them at the end of our presentation. And there are slides in the handout tab if you want to grab those and follow along with us. If you want to learn more about our firm, or if you're looking for some excellent workplace law resources, I'm biased, but they really are excellent, visit us at springlaw.ca. You'll find our award-winning blog, our monthly newsletter, and info about our innovative employer subscription programs. Again, our blogs and newsletter content is driven by what we're hearing from clients and what are pressing workplace law issues. Over to you, Lexa.
So before we begin, we would like to acknowledge that we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and that this territory is now home to many diverse First Nations, Inuit, and Métis people.
Next, I would like to run through our legal disclaimer, very high level. Basically, all I want to say is this is about legal information today, not legal advice. If you flip to our next slide, Lexa, you can all read this disclaimer at your leisure, but the point is we're sharing legal information to help you. And when you go back to your desks and deal with some of the issues we're dealing with today, the idea is to give you legal information and a place to start, but not legal advice. And we would encourage you to come speak to us or an employment lawyer for that next step of more tailored legal advice based on your situation. All right, moving on to our roadmap. I just wanted to make a couple of high-level comments before I run through the roadmap quickly. This is a really important topic and a difficult legal topic. And judging, our team's been keeping us up to date all week on the number of registrants, and we have a record number of registrants today, which says a lot to us. We know it's important to those in workplaces who are wearing HR hats, general counsel, HR professionals, or anyone with HR in their portfolio, and also employees. As I mentioned, we represent both employees and employers, and that brings a very unique perspective for us, in my opinion, because we advise on both sides of the workplace matters, and I believe it enhances our advice because we analyze on both sides of the table and we know what to expect in many cases the other side to say or how they're feeling or how they're viewing the legal issues. And I think this is particularly helpful for today's topic of accommodating employees with disabilities, especially disabilities that are invisible and often more difficult for employees to discuss and come forward with. I often tell my kids, put yourself in their shoes, understand what the other person's going through before you make a judgment or decide what you're going to say or do next. And I think that in handling these kinds of matters over the years, I think that very much applies in workplace accommodation matters with both employees and employers. So you're going to hear a lot about the importance of communicating and listening to each other. And so if you have an employer who can pause and really try and understand the challenge the employee is facing, and an employee who similarly understands the challenge the employer has in running their business or their organization, that always helps lead to a better and less acrimonious process, in my experience. almost always, never say always, but almost always, if people feel heard in the process. So today's goal, many of you will already be aware of the duty of, to accommodate and what that means, because we know our attendees are quite experienced. But if you're not, we're going to run through the basics of the law and talk about the employee rights and employer and employee obligations in the accommodation process. And more importantly, we're going to get into how does it work in practice and weave in examples, again, based on what we see from our clients and what the challenges that they're dealing with. So we'll hopefully have you prepared and equipped when things land in your inbox on your desk. And where do I start? What do I do? And how do I show my leadership team that I have approached this in a knowledgeable manner? I have the background information. I applied the tools that I learned in the SpringLaw webinar, and I dealt with it in a reasonable and responsible manner. It doesn't have to be perfect. It's a reasonable manner. So we hope that you go away today with lots of ideas. And the last thing I'll say is legal advice. We're a firm that we really believe in sharing resources, free resources, and we love when clients can take a DIY approach. Sometimes lawyers are necessary, but not always. So we share and we try to be helpful. This is an area where I do always encourage employers or HR professionals to seek advice and have a consultation and map out a plan, because it is complex and can be costly if it goes sideways. So we often will help with assessments and recommendations and written communications between the parties, the tone and content of those, and really help you to recognize when just plan the steps so that you can defend your process at the end. Final comment is this is we refer to Ontario legislation, but this subject matter applies generally the same way across most of the all of the Canadian provinces, frankly. So if you're based in another province, you can bear that in mind that this is very much applicable. So in terms of the actual roadmap, the basics of law, duty to accommodate, and we're going to drill down into what we see as the important steps: inquiring, substantiating, accommodating, communicating. Then we're going to talk about alternatives to the accommodation process and some creative solutions based on our years of experience about how we can come to a compliant outcome that works for both sides. And then we'll finish off with some best practices and takeaways. So over to you, Lexa.
Okay, so you have an accommodation issue come up in the workplace. Where should you start? Where should you be looking? Other than this presentation, there's a few other helpful jumping off points and places to look before you get started. So the first, as Marnie mentioned, is the Ontario Human Rights Code. Section 17 that we've put there is the specific provision that deals with disability accommodation. And as Marnie said, we're looking specifically at Ontario today, but the human rights laws in each province and territory, as well as the federal jurisdiction, are pretty consistent. So the broad strokes here will generally apply all over Canada. We would also love to plug the Ontario Human Rights Commission website. That's an amazing resource as well that explains in more detail and kind of more layman's terms what the rights and duties under the Human Rights Code actually mean and how they're applied and how human rights tribunals and courts think about these matters. So we've used that resource a lot when we're advising our clients and when we put together the presentation today. So that's also a great place to start. Next, you can also look at what you have in place in your own workplace. So that could be policies, sections of employment contracts. This could look like accommodation policies, drug and alcohol policies, which will be particularly relevant in safety-sensitive workplaces, which we'll talk about a bit during this presentation, or discrimination, violence, and harassment policies. Those are the most common ones we see and that will have relevant information for accommodation processes. So if you don't have these policies in place, definitely something to think about, and they're a great tool to ensure that accommodation processes are dealt with efficiently and consistently so that when something does come up, you can skim your policies and see what applies to that situation. Finally, you may have employee assistance programs or benefit plans. If you have these in your workplace, these are a great resource to point your employees to if they're experiencing any kind of health challenges, mental health challenges, and that's a great tool and something to look at when these issues first arise.
Thanks, Lexa. And just on the subject of policies, because lawyers love to talk about policies, they are important. And Lexa mentioned, skim your table of contents in your employee handbook or on your intranet, wherever your policies live. Think about which ones might apply to the situation that's landed in your inbox or that someone's brought to your attention. And I think it's a really good exercise after a session like this to go through those policies and do sort of a mock run through. Does this policy, is it relevant? Is it up to date? Is it compliant? Does it exist, first of all? And think about, would this help me and the employee, or if you're an employee, would this help you? And is it comprehensible? And does it have, from the employer standpoint, does it have onerous provisions in it that bind the employer and not give enough discretion to have the flexibility to accommodate? Like, for example, you might have a timeline. We will respond to you within 5 days after your accommodation request. Think about how that's not really workable and necessary. And that's just an example of how you might put yourself in the position of having to work through the policy. You have to follow it. You don't want to be, as an employer, in a position where you haven't followed your own policy. It's not a good start to the process. So I would say that would be a great exercise to do that run through and make sure everything's the way it needs to be in your policies. What is the duty to accommodate? So back to basics. This is a Human Rights Commission definition here. When a disability interferes with job requirement or a workplace benefit, the employer has a duty to accommodate the employee to the point of undue hardship. Put more simply, here's how the Canadian Human Rights Commission describes it. The duty to accommodate means that sometimes it is necessary to treat someone differently in order to prevent or reduce discrimination. I like to drill it down to more simple terms sometimes because there are a lot of complex phrases within the definition that have legal tests that apply. Lex is going to talk to us about disability and what that means, and undue hardship and the elements and how that threshold may be met by employers. But I think it's helpful to go back to basics and look at what that more simple definition. Sometimes it's necessary to treat someone differently in order to prevent or reduce discrimination. So let's get a little bit more granular before Lexa jumps into the tests and definitions. Let's look more closely at two overarching stages of the accommodation process, the procedural and substantive stages. So the procedural stage, you're going to obtain the required information to assess the employee's disability and the availability of appropriate accommodations. And remember, not all accommodation requests can be accommodated. This process is determined if the answer is yes or no. And if it's no, you want to be able to show you've done the analysis, and which can be onerous, and it can take a period of time to get to that point. But you want to demonstrate why the answer is the answer. And that's why it's important to understand, and we're going to go through steps in more detail, what the process is, what this procedural component is, because you don't know what the outcome is going to be. You want to be able to defend it to the employee and anyone else. Should there be litigation or a complaint down the road, human rights complaint, you want to be able to show that you took this reasonable approach in the procedure. Once you get to this, in terms of the substantive process or stage, you at that point offer appropriate accommodations, if there are any, to the point of undue hardship to allow the employee to fully participate in the workplace. So think about those two stages, overarching stages, as we drill down into more specific examples of what should be done to have this defensible, appropriate process.
Okay, so the first step in the accommodation process is for the employer to inquire. We used the word inquire really intentionally rather than something like investigate, because we don't want this to be painted as adversarial or punitive in any way or viewing an employee with suspicion. We mean this as information gathering with a view to understand the employee's needs and how the employer can best accommodate them and meaningfully fulfill both those procedural and substantive steps that Marnie was just talking about. So in the inquire stage, the first question is, does the employee have a disability? Therefore, triggering the duty to accommodate under human rights law. So if there is a disability within this definition, there is that duty to accommodate, and that's when all of these other steps are triggered. So this definition is from the Ontario Human Rights Code, and as we've said already, any differences in other provinces will be minor. I won't read out this rather wordy definition, but we've just put it here to illustrate that the definition of disability is really broad. And so generally your starting point for dealing with a disability accommodation issue will be to assume that whatever the employee's condition, it is likely included within this definition. If you're receiving a medical note or something like that, you should really be operating under the assumption that it is captured within this, and it's not really the employer's place to be second guessing that. And as you can see, it's a big definition and it encapsulates a lot. So types of mental health issues, most commonly in our practice, we see anxiety and depression, but this can also include learning disabilities, neurodivergence, addiction, and so many others. So yes, definitely broad. So receiving accommodation requests and the duty to inquire. Usually an accommodation request will begin with a request from an employee. Usually an accommodation process will start with a request, but employers also have an active duty to inquire where the employer should reasonably be aware of a need for accommodation. The importance of the duty to inquire is going to be one of the differences we see between physical and mental disabilities. Mental health issues are often going to be invisible, and employees may be reluctant to come forward because of the continuing social stigma regarding many mental health issues. So there is, the employer can't just rely on, oh, they never told me, they never came and gave me an accommodation request in writing. If you reasonably should have known that someone was struggling, that triggers the duty to inquire and should have triggered the accommodation process. So there is a real active component that some employers may not be aware of. So some examples of things that could trigger the duty to inquire and should maybe get those, flags raising in your mind, is the employee calling in sick a lot? Are they not performing to their normal standard? Are you receiving unusual client or customer feedback on their performance? Have they gone through a big life change recently, death, sickness, divorce? These could all be signs that you should inquire further if the employee is dealing with a mental health issue and requires accommodation. Following up on signs of disability is particularly necessary where an employee is exhibiting signs of a mental disorder or substance use disorder. They may feel stigmatized and fearful to disclose the disability or may not be fully aware of the disability. Employees may not know that employers have this duty to accommodate and may be fearful that disclosing it will have negative impacts on their career or the way they're perceived in the workplace. So these will be even more important if an employee is in a safety sensitive position, if they're working in a manufacturing environment or using heavy machinery, and you have reason to believe that they may be dealing with drug and alcohol addiction or some other mental health issues that may be impacting their ability to safely perform their duties, you should absolutely inquire with that employee. Obviously, just saying inquire is easier said than done. It's going to be sensitive, may be difficult to broach the subject, should be discreet, maintain confidentiality as much as possible, and really just create a safe space for that employee to know that you're there to help. You're not looking for confidential medical information or to grill them on any of that. You just want to be able to understand any issues that they may be having and that you may be able to accommodate, and letting them know about the duty to accommodate and the options and supports they have available to them. So maybe as simple as saying, we care about you. Here's our accommodation policy. Let me know if you have any questions. I'm here if you need anything, right? Just letting them know that those options are available to them. And again, that's why a policy can be really valuable and something to rely on in those situations, and something easy to point an employee to in that context. Oh, did I go backwards? Yeah, there we go.
All right, we're on substantiate right now, right? Is that right? It's number 2, step 2, substantiate. So as Lexa said, as an employer, you generally want to accept the accommodation request in good faith. And in meeting the duty to accommodate, employers can request sufficient medical information from the employee. And a lot of what we do is help, well, especially where an HR professional we're dealing with hasn't had experience with it before. It's very important to plan the first communication with the employee. It doesn't have to be long. Lexa gave a couple of examples of, we care about you, here's the policy, this is how it works. It might be a more detailed conversation, but the point is to prepare in advance and think about the person in the situation and what you're going to say. And it might be a little bit tailored to the personality. You want to treat people consistently, but preparing some talking points and considering what you're going to talk about in the meeting, video call, whatever it is, and following those talking points is important, so you avoid too much deviation. If things get emotional or difficult in the meeting, you generally want to have a plan and stick to it, and that will become the memo to file in the accommodation file that you create. So you want to be human and empathetic and hear the person and listen carefully, because they might volunteer information that's important in that meeting. But this is all part of the substantiate process. You need to hear from them so that you understand what the next steps will be in considering how to accommodate. So explaining to the employee of the process so that they don't feel like this is an investigation or something punitive is really important, because often employees feel like employers are trying to pry if the communication isn't done well, or they haven't explained that this is standard and this is how we approach things for every employee, and let's work together on it, and it'll lead to a better outcome. Is how you want to sort of get the employees buy-in and have them trust that process. So you want to have them understand, just back to the 3 bullets about when you're requesting sufficient information, you understand whether the employee has a disability, which would therefore trigger the accommodation process, and understand how the disability restricts the employee's ability to work, to do their job, and then determine what accommodations, if any, might be appropriate in light of the restrictions. So that's, and understanding that process and the purpose of the information is helpful when you're talking to the employee. We're not prying, this is why this process is necessary, and get into a little more detail about the why. And so moving on to the next substantiate slide, in terms of specific steps, it all starts with the medical documentation from the medical practitioner. So family physician, psychiatrist, whoever they're seeing, again, accept that note or document in good faith from whatever medical professional they propose, and then if it's not adequate, you decide at the time and maybe ask for it further medical at the time. But a functional abilities form might also be in order, and employers typically have templates of the kinds of things they need to know for certain roles. And in terms of when we seek medical information, we're working with employers to obtain medical information from the practitioner. I always recommend, again, looking at the specific situation. I find it works best when you send a covering email or a covering letter to the doctor, and with a job description that describes the employee's role. Maybe a say in the covering letter, look, so-and-so is a valued long-term employee. We're trying to help them with a healthy and safe return to work. Here's their job description. Here's the questionnaire that we have tailored for this person, or it's your generic questionnaire if that suffices. Could you complete this and return it by X date? And this really helps the doctor understand the process. They might not have experience with accommodation in the workplace, and offer to pay for the report and state that in the letter. And I find that leads to more information from employers, doctors, because sometimes you get a 1 or 2 liner back that's really not helpful, and that sets the process back a few days or weeks if they go through that. And then employees get frustrated, they have to go back to the doctor again. So trying, and this isn't required in every case, but often where you're getting further down the road and you're just either too many unknowns, it starts with a medical practitioner's opinion. I always say to the employer or the employee, I'm not a doctor, you're not a doctor, or your medical practitioner, and that's where the opinion starts there, and that's where we build from. Then we need that recommendation and advice. You want to make sure that the requests for information are as minimally intrusive as possible. And so always respecting the employee's privacy to the extent you can and demonstrating that you're doing that. This isn't a fishing expedition. Information should be limited to the nature of the limitation or restriction to assess the employee's needs unless the employee volunteers more information. So sometimes they will do that. And sometimes if I'm advising an employee, I say, are you comfortable sharing more about what's going on, because you've demonstrated this as an employer who understands the process, you have a good rapport with whoever you're dealing with, how about this? And sometimes they're okay with that, and when you're on the employer side or the HR side, GC side, it can be helpful. So listen carefully to what they might volunteer, and that might lead you down a different path. In some cases, disclosure of diagnosis is required, and it's appropriate to request that where it's reasonable and necessary is what the case law says. And many people don't realize this. It should, employers shouldn't proceed with caution for sure. Diagnoses should not be requested flippantly. And by diagnosis, we're talking about a formal medical name of a syndrome or condition, as opposed to the nature of an injury or illness, which is more of a general statement about a person's illness or injury in plain language without any technical medical details. So if you're going to ask for a diagnosis, it has to be reasonable and necessary for the employer to accommodate the employee or assess the legitimacy of the request. So sometimes you get into a situation where, frankly, there's just no basis. It doesn't make sense. The request is out of left field. You're not sure if it's legitimate. It happens, and it's too bad because it makes it more difficult for those who truly are suffering, but it certainly happens, and that's why this process is in place. And at the end of it, hopefully the employer has a real sense of what's happening in terms of nature of illness and injury, so that they can prepare an appropriate accommodation plan, if any. So it's the rare situation where you ask for the diagnosis, and that's where person's accommodations needs are complex, challenging, or unclear. And then so you can ask the person to cooperate by providing more information up to and including the diagnosis. And of course, you're always going to maintain confidentiality as far as possible. Sometimes you do need to share with a leadership team member or so on. I would be very transparent with the employee about that. Look, I respect your privacy. We want to do that. That's how we always approach these things. What I think would be helpful is if I discuss this with so-and-so and share that with them, because you don't want to be in a position of having shared something very personal that they don't want shared. And if they refuse and you think it's necessary, then you have that conversation about why it's necessary. So it's all about transparency and communication and getting the employees buy-in to understand why these things are necessary. So it's a tricky balancing act of respecting the employee's privacy while requiring sufficient information to assess the accommodation request and explore potential accommodation solutions. Lexa has an excellent blog on this topic, and we've hyperlinked it at the end in the takeaways, and highly recommend it. It's a good starting point in addition to this session that's a bit longer, but she talks about when you can and you might be able to request diagnoses and all kinds of other things in her blog. On to step 3.
Yeah, so step 3. So you've inquired, you've substantiated to whatever degree necessary in the circumstances. Now it's time for the actual meat and potatoes here, the actual accommodation. So the first, right off the bat, we can say that the duty to accommodate mental health disabilities or mental syndromes is no less onerous than the duty to accommodate physical disabilities. So there are a few guiding principles employers should keep in mind when developing accommodation policies and when implementing accommodation processes with individual employees. So the first is individualization. There is no set formula for accommodating people's disabilities. Each person's needs are unique and need to be considered afresh every time an accommodation request is made. So you could have lots of employees with anxiety and each one may need a different accommodation. It's not, this is the accommodation for this issue. It's going to be individualized for each person. So what might work for one person may not work for others. A solution may meet one person's requirements and not another's. Similarly, these accommodations are not static, just as people's mental and physical health are not static. They may need to be revisited over time as people's situations, life situations, and symptoms or ability to cope with certain things changes. So you need to continue, you may need to continue to revisit that, or certainly keep the door open with the employee to let you know as things change. The second guiding principle is integration and full participation. So this is really the overarching goal of all accommodation, right? So we want to facilitate integration and full participation in the workplace for people, regardless of whether they have a disability or not. So as Marnie said at the beginning, that can look like treating people differently to ensure that everyone has the same outcome and feels integrated and are able to fully participate in the workplace, and designing a workplace that is barrier-free and inclusive. So this is something else that can be sometimes more challenging with mental health versus with physical disabilities. I think we're all pretty attuned at this point to, wheelchair ramps and accessible washrooms and providing services maybe with Braille, or those types of things are easier to see, they're more tangible, so it can be more challenging, but definitely worthwhile to be thinking about how to create an accessible workplace, not just in terms of physical differences, but also mental health disabilities as well. So the last guiding principle is appropriate accommodation. So the duty to accommodate requires that the most appropriate accommodation be determined and provided unless this causes undue hardship, which is something I'll talk a bit more about in a minute. So accommodation is considered appropriate if it results in equal opportunity to enjoy the same level of benefits and privileges experienced by others, or if it is proposed or adopted for the purpose of achieving equal opportunity and meets the individual's needs. So this accommodation process is a matter of degree. It's not an all or nothing proposition. It can be seen on a continuum. So the highest point of the continuum of accommodation must be achieved short of undue hardship, right? So there may be a perfect accommodation for the employee, but it may not be feasible for the employer. So how do we come down that continuum to accommodate the employee as much as possible while it still works for the employer and they are not under undue hardship? So it's that kind of give and take. It's a balancing act, and there's no set formula that we can give you. It's going to be different for every employee and for every workplace. Every role is going to look a little different.
I just wanted to add on, sorry, Lexa, just on the undue hardship assessment, that is one of the complicated areas of duty to accommodate, law of accommodation. And that is an area where we talk to employers and work through, are you reaching this threshold? And if you believe you are, how are you going to substantiate that? And so, what's happening to the business, and, make note of client feedback or things that might be happening because the workforce has shifted or we've had to modify things, and think big picture about undue hardship under the various categories. So it's something that you need to think about from the beginning, so that you can track it and assess whether you're reaching close to that threshold.
Yeah, absolutely. So this slide here, as we've plugged before, this is based on guidance from the Ontario Human Rights Commission. So this can really be used like a checklist when you're going through an accommodation process, when you're creating any policies. This is a great tool. So the accommodation process is a shared responsibility. It's not just an employee makes a request and then, it's all on the employer to figure this out. It is a shared responsibility, and the employer and the employee need to work together to come up with accommodation solutions. So the employer's duties are generally going to be more onerous. They have the power in the relationship and the inequality of bargaining power there, but the employee still has to participate. So some of those duties are make their needs known, unless it's a duty to inquire situation, as we were discussing, but generally employees should be making their needs known to their employers. They should answer questions, provide information regarding restrictions, including providing information from healthcare professionals. So this is that substantiate piece that Marnie was speaking about earlier. They should be taking part in discussions regarding possible accommodation solutions. So it should be like a team effort. It should be a discussion, a conversation. It shouldn't be one side proposing things without feedback or input from the other side. Continue to meet job standards once accommodation has been provided, right? So once they've received that accommodation, once they've received maybe that not treating people equally so that they can participate equally, once they've received that accommodation, then they are still expected to then participate equally in the workplace and meet their job standards for their role. And finally, work cooperatively with accommodation providers and experts. So depending on the organization, depending on the complexity of the accommodation issue, some employers may bring in, outside consultants, or some companies provide these services. So employees are expected to work cooperatively with any of those folks that are brought in as well.
The next slide is a mirror of the one that Lexa just walked us through, and that's the employer duties. And I would flag these slides 19 and 20 and keep them handy, as Lexa said, and use them as checklists for that process that you hopefully never need to defend, but you can say, this is how I view it. I understand the two-way street that is accommodation and the obligations on both sides, and whether you're an employee or an employer handling it, be aware of both sides' obligations in the process. And this is your starting point, as Lexa said. This is from the Human Rights Commission, and it comes from an old case, and it hasn't changed a lot over time. So a great starting place. I'm actually not going to read the bullets because I think we've touched on most of them. Just star it and keep these two handy. And I am also going to say I'm reading the questions that are coming in. There are lots of them. They're great questions, and I think we're going to address a number of them with our slides. So, but I am aware of what's being asked, and we'll try to hit them, and then we'll have time to address a few more at the end. So I think we can move on to the next slide.
Sure. So next is as we've mentioned a couple times, undue hardship. What is that, right? So the duty to accommodate is not absolute. The employer's obligation to accommodate an employee with a disability goes as far as the point of undue hardship. So unfortunately, undue hardship is one of those lawyerly concepts that cannot be easily defined, and it's going to be different in every circumstance, every industry, every employer. But there are a few different kind of broad categories of factors that can be found to constitute undue hardship, and that there is case law on these factors. So the first is core duties. So the employee must still be able to perform basic job duties with an accommodation. The duty to accommodate does not include altering working conditions in a fundamental way. If you're familiar with your human rights case law, you may also know this as a bona fide occupational requirement. These are similar concepts. That is a little bit more legalistic and lawyerly, so we're not getting too far down that rabbit hole today. But yes, you do not have to be altering an employee's job duties in a fundamental way. You need to be providing accommodation that allows them to perform those key job duties, but they still need to be able to do them with accommodation. So for instance, if someone is a forklift driver and they have restrictions that prevent them from driving a forklift, they can't drive for whatever reason, the employee would be unable to perform their basic duties, and even with accommodation, short of undue hardship. So that could be a situation where that would be undue hardship for the employer to accommodate them. Where we see this come up a lot, especially recently, is when employees make accommodation requests to work from home. This is obviously a big hot topic in the HR and employment law world post-COVID. And in many industries, it will be challenging for employers to show that attending the office is a person's core duty or occupational requirement when they have been working from home, maybe during COVID or since. So that can be a really tricky one, and one that we see come up a lot. And this can conflict with many employers' return to office plans. But it's something that definitely engages this type of analysis here, and that may be difficult to prove. The next is safety. So even if there is an accommodation available, employers do not need to provide it if it would pose a substantial safety risk. So this is going to be a pretty high bar, and it's most likely to arise in safety-sensitive workplaces. So dangerous machinery, chemicals, workplaces with vulnerable populations like schools or hospitals, or workplaces with a high likelihood of violence like police forces or military. So as an example, if someone has an addiction, they may be able to be accommodated if they work in an office as an accountant, but if they work as a preschool teacher and are in charge of the safety of children, accommodating that disability could likely amount to undue hardship and would not be something that the employer could accommodate in that case. So it is just really fact specific. And finally, cost. So for cost to constitute a valid defense of undue hardship, it must pose a significant burden on the employer's operations. And this is a really high threshold to meet. It's not enough for the employer to say that the cost would be undue hardship. For instance, if you end up going to a tribunal on a complaint of discrimination or failure to accommodate, it's not enough to just say it's undue hardship because it's too expensive. You would need to show accurate, objective evidence of the cost of that accommodation and why you couldn't do it. So this will be really high threshold to reach and likely impossible for larger employers. It's going to be really hard to show that something is too expensive for you to accommodate someone. It's really going to depend on the business and the workplace, and the standard's going to be very different for a multinational corporation versus a mom and pop shop. So it's going to be really contextual, but larger employers, courts and tribunals are not super sympathetic to employers saying it would be too expensive for certain accommodations. So that's something to keep in mind. And then finally, just some accommodation examples. So as we've said a couple times now, it's going to be really individual to the employee and the workplace. And there's as many types of accommodations as there are employees. The possibilities are endless. And so these are just a few kind of common examples that we see. So modifying job duties and deadlines, modifying break times or policies, so allowing maybe more breaks or breaks at certain times, allowing flexible work schedules, so starting late or starting early, ending early, these types of things, maybe allowing folks to be able to attend medical appointments, things like that with flexible work schedules. And finally, probably one of the most common ones that we see is allowing time off for recovery or treatment. So allowing employees to go on leave or to take time off to attend medical appointments or get treatment, things like that.
All right, on to step 4, communicate. We've been talking lots throughout this session about communication. So really it could be step 1, or it could be at any stage. It's important from start to finish. And what you want to do is implementing accommodations promptly is important once you've communicated enough to understand if there's going to be an accommodation, if there can be an accommodation. You want to keep this, the important part about this slide, I think, is around communicating with employees. And I'm seeing some questions about this from attendees. And this is an interesting one. You want to keep employees informed throughout the process. And likewise, the employees have an obligation to communicate on a regular basis with the employer. And this can vary. And we do see situations where employees are in a really tough spot, and every reach out or communication with the employer is very stressful for them. So it's important to, first of all, think about who's communicating with the employee. Is there somebody in the workplace that has a special rapport with them where it's going to make it more effective? Maybe have that person communicate if you have a team of people who have the skill set or able to, or don't have the skill set but could be trained to work with the employee, and figure out a schedule or cadence of communication with the employee and agree on it and say, you know, we might have to deviate at times, but why don't we agree on, you know, once a month or every couple weeks, and that we'll need updated medical at these intervals, and depends on the situation, but you decide and you work with the employee and you ask for the feedback. And in any of these communication situations, you don't have to agree to the employee's request, but make sure they feel heard and explain why it needs to be slightly modified or it needs to be this way, and make sure it's in line with what we're talking about, the duty to accommodate. So be reasonable, but set it out so they know what's required of them and what's required of the employer. There was a question that asked about trauma-informed inquiries, basically, you know, where employees are, I think that's the situation I described. You need to be empathetic and especially sensitive to the situation. And I think that asking them what would be okay in terms of communication is the best place to start. Again, you don't have to give them everything they ask, but it's going to make sense to work with them in most cases. And you're always also going back to the medical documentation and reviewing what information is helpful from there. And if you don't have it, there's lots of questions about the back and forth and what is sufficient medical information. This is what gets really tricky. You have to be persistent, and hopefully the employee is going to be patient with the process if you're not getting the information you need to assess the accommodation. And that's where things can become strained and acrimonious. And that's why this starting with an understanding of the accommodation process and strong communication from the beginning can really help, because the employee is often already struggling and feeling like an employer is just putting up hurdles and trying to force them out and trying to fire them and all kinds of things get going in their minds sometimes, which are usually hopefully not accurate, but it's not a great situation to be in where you're being asked by, and there's often insurers involved as well that have regular communication. So level setting with the employee as far as possible with the right person at the employer's workplace to communicate with them is I know it sounds a little Pollyanna, but we've seen it done, and it can work with some planning and the right individuals involved. I've already talked about checking in at reasonable and agreed upon intervals, and recording all the steps you take. A little bit more about documenting. We've talked about documenting your accommodation process so that, well, number one, it's well thought out, and your meetings and your conversations with the person seeking the accommodation is you know, it's a well thought out planned process. But also you may have to defend your process at some point if there's a complaint made or litigation. That's the other. This doesn't often happen, but you want to record your steps for that purpose as well. So be mindful when you're communicating, when you're making notes and recording your process. Sometimes a less is more approach is helpful. You don't want to go overboard and write comments. We've seen this, comments that are sort of your viewpoint that are not relevant to the accommodation process, like, you know, I showed up at work each day for 3 days in a row. So-and-so was there telling me why they need to work from home. That narrative's not important. It's that they've made a further request from work from home. I suggested that they provide updated medical information and look forward to receiving that within a week. I'll follow up with the employee at that point. That's the kind of record keeping that we're talking about. So when we say document, it's that you record your steps with a view, now that you understand the process and the law around it, and not unhelpful narratives, because you know, if it becomes acrimonious or litigation does follow, your notes, unless they're privileged communications with counsel, it may be producible in that process. So bear that in mind. And again, the starting point is understanding what's needed and collect that information and make sure it's contained in your accommodation file. Now, alternatives to the accommodation process, we're nearing the end here. This is, someone did ask about frustration of contract, and that could be an entire session on its own. Lexa and I discussed when we were preparing yesterday how to address the frustration of contract. And high level, I think what's important to consider is there's no set time frame where an employee's been off and unable to perform their duties, where the frustration of contract is triggered, meaning they can no longer perform their duties and the contract comes to an end. There's case law showing varying time periods where frustration might be found to have occurred. A 2-year mark is a rough guideline where the case law, and it comes all down to the medical. So if a medical practitioner has said there is no reasonable prospect that this person will be able to return to their duties or a comparable role, that's the starting process for, well, there might be frustration here. So it could happen at a 6-month mark if somebody's not, if a medical practitioner has decided or determined and given an opinion that they're not going to be able to return. But typically we say to employers to not reach out to us or have that conversation until you hit the 2-year mark, unless there are extenuating circumstances. And at that point, there may be frustration and there might be a communication with the employee about that's what the employer is thinking, which would trigger their ESA entitlements and an end to the employment relationship. So that is an option, and that is certainly a situation where you should seek legal advice before communicating with the employee about that. Mutually agreeable separations. When we talk about alternatives to the accommodation process, I mean, there's always a duty to accommodate, but sometimes early in a situation, we have employers come to us and employees, frankly, and employer might say, look, we're in a very difficult situation business-wise. You know, is there any opportunity here for a different path? And we say, you know, if you've listened carefully from the beginning in conversation with the employee, have they expressed a desire to move on or retire or pivot, and if they have that, they've opened the door to that conversation, and make sure you've made a note of that conversation, that they've expressed perhaps a desire to have that conversation. So that conversation with them needs to be well planned out and carefully planned with talking points, and you want to proceed with caution. And you might get to a point where you find a solution that works for both sides. You might have an employee who is very stressed out by the workplace and wants to pivot and move on and would be open to a mutually agreeable separation. And from a business standpoint, the employer might say, this works. We've actually had somebody in the role, fulfilling the role, and you know, they can do it, and it's all working well in this employee's absence. We understand our legal obligation, but this person has broached this topic, so let's talk about what those terms might look like. And I usually recommend that the employer contribute to legal advice for the employee to obtain independent legal advice, so they understand what they're agreeing to. That makes any negotiated settlement defensible down the road, because you know they've received advice and they understand that what signing a release means, and they might have a conversation with their lawyer about re-employing and what that might look like, and do they want to move on from this role, and have that, you know, ILA conversation with their own lawyer. So we have negotiated over the years many positive outcomes that do not need to become acrimonious, and that's what I mean about when we talk about a mutually agreeable separation, where you hammer out terms and it's a without prejudice settlement that can work for both sides. The last bullet refers to where an employer would have made the decision to terminate the employee without any disability or Human Rights Code protected ground. This is some similar analysis applies. And they're in a situation, like for example, an employer might have made the decision to terminate employment, and then the employee discloses a disability after that decision's been made. All the plans are in order, a termination letter may have even been drafted. And in those situations, those are difficult facts for an employer, because they have to show the decision had nothing to do with the employee's disability, and I mean nothing to do with it. It can't even be a factor in the decision, and so that's where communications and record keeping and so on needs to demonstrate that that wasn't a consideration. This is a business decision for unrelated reasons. The employee's performance that you've assessed over time that has nothing to do with their disability, that can be a difficult assessment, a thing to prove as well. but the decision is unrelated to their disability, and that terminations can happen in that situation, and it would not be discriminatory if it wasn't a factor, the disability was not a factor. Having said that, it can be difficult to prove and establish, so that the disability is irrelevant. So you do the risk assessment. We often do this with employers and say, this is why it might be difficult to establish this. This is why a fact finder may not agree with you. And the person might be entitled to a greater severance package in that situation. And we look at what their entitlements would be and talk about what a potentially agreeable exit would be, where the employee wouldn't claim discrimination and say, this works for me. This is a good outcome for me. I'm not going to dispute this termination, and they settle, and there's a negotiated resolution before a legal dispute arises. So that's another scenario where we've had, I would say, good success on both sides. Obviously, this is never a good situation, especially for the employee, but they are sometimes in a situation where they get to pivot to a new role, take the time they need to focus on their health, and they have a severance package that they have hopefully gotten advice about and signed off on, and there's a parting of the relation and end to the employment relationship that is a positive for both sides. And that was an important conversation, I think, because a lot of employers ask us what are our options, what kind of business decisions can be made. So that's where we really work with employers and employees who assess when this conversation has been broached with them. All right, moving on to takeaways. So our last slide, over to you, Lexa.
Yeah, so you know, some of the major things that we think are important here to take away. One is that employers have a duty to inquire where they should be reasonably aware of a need for accommodation. So in certain circumstances, it's not enough as an employer to wait for an employee to make a formal request, and it will not be a defense to say, oh, they never made a formal request, oh, they never filled out a form, right? There is an active duty to inquire, and that's important. Next, just a general overarching theme, I think, and that's going to serve employers well, not only from a legal standpoint, but just from a business and employee morale and a human standpoint, is to accept accommodation requests in good faith, unless there is a specific reason to have doubts about an employee. Accept those requests in good faith. And both employers and employees are required to participate in the accommodation process. So it's not one side or the other, it's a shared duty, and it's a collaborative process throughout, which is something that's important, and both employers and employees may not be aware of their own duties there.
My turn. I was reading some of the questions, see what we've covered. Lexa was supposed to do all the takeaways, but she didn't want to plug her own blog, so she made me take the last couple of takeaways. But I'm plugging it again because it's great, and she's very knowledgeable in the area. I think all these takeaways have been covered over and over. You know, the point of employee accommodation to the point of undue hardship. Hopefully, we've given you some tools to assess and to plan ahead and understand what that test looks like, and so you can keep records of where you might be inching towards that threshold, so that, and you can get legal advice, I think, is recommended once you're starting that analysis. Communication is key and can lead to these creative outcomes. So work with your employee, and if you're an employee, work with your employer, and throughout the whole process. Record keeping and documenting, I've talked about. I'm sure you're tired of hearing about that. Lexa's blog, check it out, and all of our blogs, because we really do try to give advice on, and so that will help you decide if and when you need to seek external employment law advice. So that brings us to the end of our formal planned session here. Let's just skim. We have 3 minutes left, and I hope we have a lot of questions, and I've been skimming them throughout. Let's see. Yes, you can access a recording of this afterwards. That's the easiest question that's been asked. We aim to make the presentation and webinar recording available on our YouTube channel and our website 48 hours after. we will also send the recording through our newsletter. So that was an easy one. Anything else we can jump in on there? Lexa, other questions? How do you respectfully ask an employee if they need accommodation because they've observed certain things, but they themselves don't think there's anything wrong? I think in that point, you need to bring forward the performance issues and show it to them and say, look, they were not delivering, or we've had client complaints about responsiveness or whatever it is, and objectively put the issues to them. This is where having performance measures and clear job description is very helpful, because the more objective you can be, the easier it is. They don't feel like they're being attacked or picked on. And the more you do regular performance reviews of all employees, the more it looks like you're being consistent, treating everyone the same. So all of those processes in the background really help. But here, respectfully asking them if there's something going on is if they're not performing and they're not meeting expectations, then you're going to have to press a bit harder on the issue, which gets to be an uncomfortable conversation. But you know, if they're not performing, they're not performing, and the employer is entitled to pursue that.
Yeah, I would also say, you know, in either case of, you know, if an employee is asserting that they have a disability and you don't believe them, or if you think they have a disability and they don't think, you know, employers are not doctors, unless you are, but you're not your employee's doctor. And so it's not really our place to second guess that. It's our place to let them know about what supports are available and what their rights are and what the employer's duties are, and then leave that space open for them. But otherwise, then if you've given them that opportunity, then you would continue on with whatever performance management you have in place, as if there wasn't a disability.
Here's one final question. I don't think we've touched on this, and then we'll have to wrap up. But please feel free to reach out if you have a specific matter, and we can certainly assist. Some of these questions are very specific. So beyond the scope of, I think, of today. What if the employee is not complying and providing the FAF, but the employee continues to say they need accommodation? They need to understand the process, and that's where at the outset, describing the process and what the expectations are of this two-way street shared responsibility that we've talked about, that's important. And at some point, it becomes a disciplinary issue. Like if they're not complying with the accommodation process, like as an example, if somebody has is battling addiction and they're meant to be in treatment and following that program and they're not, at that point it becomes a disciplinary issue, and the letters to the employee need to become what would sound punitive to some people, but they're not complying the accommodation process, which they have to do. So it's never a good thing when it gets to that point, but there is a line where the employer is entitled to say this is not working. Okay, I think that thank you very much to everybody for attending and asking such engaging questions. We appreciate it, and look out for the presentation on our YouTube channel or on the website within the next 48 hours. That's it for today. Thank you very much.